get to that car, and it's hard.
So you're asking the court to approve the default judgment?
Correct.
No further questions, Your Honor.
So, Ms. Escudero, I think this is one, thank you, Mr. Mata. I think this
Yes.
is one where we had previously set it for default hearing and there was no motion filed, right?
Yes.
Okay, and now I'm seeing the motion was filed on September 10th, so about 8 days ago. How did we attempt service on Mr. Gonzalez?
Your Honor, I have the proof of the USPS tracking where we send it by certified mail, and we have the tracking. And so I would like to get that admitted as Exhibit 1.
Okay, is that attached here? I quickly went through. No, there's a letter.
It is not, Your Honor. I just have the tracking.
Okay, so that's not the tracking that is Exhibit 2 to the motion doesn't pertain to this particular hearing. Is that right?
Correct. That pertains to the demand letter that was originally sent.
Got it.
And then I have the updated one that I'm going to mark as Exhibit 1 for the court.
Okay. Okay. And it shows delivered, or what does it show? Do you have it electronically, like where I can see it on the screen?
Yes, Your Honor.
Okay.
Could I share my screen?
Mm-hmm. Okay.
I don't know if the court is able to see it or if you need me to zoom in.
So this is to the business, I guess the EPTX Motors, is that what it is?
Yes. Yes, Your Honor.
Okay.
And so it was delivered on September 11 at 8:36 a.m.
Okay. All righty. If you'll go ahead and email that if you haven't already to Ms. Hernandez as, I guess, an Exhibit 1 to the hearing, or do you want to number it? What is this? 6? Since I'll be considering your motion and the exhibits that were attached to your motion, if you'll just include that as Exhibit 6. Okay. What else do you have to say, Escudero?
I would also, as a final matter, would like to, if the court would want me to testify as to attorney's fees, or just to take the motion as it is, stating that me and Mr. Mata have both worked on it with the amount of hours, we reduced it. I would like to admit Exhibits 7 and 8, the log of the hours and the work that we've done and how much we've reduced it. I'm only charging for 5 hours and he's charging for 10. In the amount of $5,300 to be reimbursed to legal aid.
Okay. If it's not an affidavit form, what do you have? Just your billing? Is that what those exhibits are?
Yes, Your Honor.
Okay. If it's not an affidavit form, then I will take testimony from you, Ms. Escudero.
Okay. My name is Vianney Escudero, and I am a licensed attorney in the state of Texas. I have been licensed since 2019. I have a Juris Doctorate from the University of Michigan. I am currently employed at Texas Rio Grande Legal Aid, and I represent Mr. Juan Pablo Mata in this case. I have personal knowledge of this case and the work performed. I have marked as Exhibit 7 a log of my work in this case, and I have based my hourly rate on a 2013 survey from Texas Lawyer, which estimates that a fourth-year associate hourly billing rate is about $260 per hour. And so I am basing my fees as a sixth year at $260 per hour. Legal aid is requesting to be reimbursed for the work that I put into Mr. Mata's case in the amount of $1,300, which reflects 5 of the 10 hours that I have worked on this case. These hours include work that I had to do to prepare our client for this hearing, familiarize myself with the case, prepare for this default hearing, and prepare the default judgment. Mr. Mesta, who was previously working on the case, has been an attorney for 22 years and is also licensed in the state of Texas. He is a NACA member and has been awarded attorney's fees in previous consumer cases. His rate is based of $400, and I am attaching as Exhibit 8, Mr. Mesa's billable hours and work in this case. We're reducing his work down to 10 hours, and that will reflect an amount of $4,000. And so legal aid is requesting to be reimbursed a total of $5,300 for the work in Mr. Mata's case.
Alrighty, thank you. The court will await receipt of those additional exhibits. What else do you have, Ms. Escudero?
That is it, Your Honor. We rest.
Okay, so I'm trying to understand here. Talk to me about the amounts requested. I think the vehicle it's here is represented was purchased for, was it $2,500 or $3,000? No.
$3,000, Your Honor.
And you are requesting a judgment, a default judgment in the amount of $143,700 plus attorney's fees?
Yes, Your Honor. So we're asking that Mr. Mata be awarded $38,900 in economic damages. And so that includes the $3,000 that were what he paid for the vehicle. And then $35,900 for all the expenses that he's had to get Ubers. And it's also the amount of money that it would have cost him to rent the exact same vehicle same year for the time from when he purchased the vehicle but could no longer use it until the first hearing date, which was back in June, I believe. And so those are the economic damages that we're requesting for then, because he couldn't afford to buy a different vehicle and Mr. Mata had to be driven around by other people. And so he had to use his own money to be able to move around, especially for his medical conditions. He had medical appointments and things like that. And then we're asking for a total of $9,000 for his mental anguish damages, for the pain, not only from having to walk around, as Mr. Mata stated, he has a lot of different medical conditions. And so a lot of them got worse through this time, through the stress, through having to either move appointments or things like that. And so we're asking for mental anguish damages of $9,000. And so that totals it to $47,900. And then we're asking for treble damages, because under the DTPA, you can ask for treble damages. So we're tripling that. And so that would come to the amount of $95,800, which is a total of $143,700.
All right. Please forward your exhibits. The court will review all the exhibits, including the motion for default judgment, and I will submit a ruling. Thank you very much.
Thank you, Your Honor.
Have a good day. Thank you, Mr. Mata.
You too.
All right. Who's next?
Page 3, Judge Palma Page, calling cause number 2022 DCV 3519 Lluvia Bañuelos versus Luis Mendoza Flores. Announcements, please.
Joshua Murphy on behalf of defendant Mendoza Flores, Your Honor.
Mr. Sanders, you're muted.
Charles Sanders on behalf of the plaintiff, Lluvia Bañuelos.
We're set for a status conference. What is the status?
All right, Your Honor, we have mediation set in this matter on the 28th of October.
Where are you all mediating?
This is with Ancliffe Mediation, Judge.
Okay, I'll reset your status conference for October 30th. Thank you for your time.
Thank you, Judge.
All right, who's next?
Last case, Judge, I called Mr. Rincon. He's supposed to be logging on. He hasn't logged on yet. You want me to go ahead and call it?
Your Honor, good morning. I'm here on behalf of our firm. This is Sergio Chavez. Yes, ma'am. On the one that I believe is being mentioned.
And
Okay.
Ms. Labinati is here, so we are missing Mr. Rincon.
Well, he's the Sergio
So,
Chavez is
Oh, I'm sorry.
yeah, so I am with Rincon Law Group, Your Honor. Yes, ma'am,
Oh,
I am
okay.
here on the case.
I apologize, Mr.
It's
Chavez.
okay.
Okay, so are we missing anybody else? No, huh? Because Amado Montoya also. Yeah, so we're good. Status conference. Let me see.
Good morning, Your Honor. If I think I've been told what's going on in the case. We had mediation scheduled for this Friday, and but we went ahead and that's been taken down. There was some new medical new materials provided, so it's going to change the dynamic of the case somewhat. So we felt in order to have a better mediation, that was taken down. The parties have done some written discovery, Your Honor, and depositions have also been taken of the plaintiff Quinones. And I believe that
the defendant as well. The depositions have taken place in this case. We've gone to mediation once. Case did not settle. This was second mediation, and suddenly, without any additional notice, I get an email yesterday saying that mediation got canceled because of, we filed the NOI. Plaintiff was treated, Your Honor. So, I mean, they had that information. I don't know, but either way, I was very disappointed to see that the mediation got canceled, especially with Judge Villa, that, it's so hard to set mediation. And so I have reached out to Carlos, sent him several text messages saying, hey, Carlos, is there a way you can look at that file and make sure this mediation does not get canceled? But I have not received a response. So based on Sergio Chavez's representation right now, I guess my efforts are not going to go anywhere. So I really would like to get this case. I know that they asked me for a favor, that they wanted to continue it. This is an old case, so I will work with the defense bar. So I have no problem working with them, Judge. But let's get this case as full and final special setting. I would appreciate if the court orders the defendant to go to mediation before the end of the year, if possible, and maybe Judge Villa will give us he's retiring, Judge. So my fear is that, next year there will be no Judge Villa, and I would I think well, Judge Villa mediated this case once, and so he knows the case well. So I would appreciate if, we can finish with him. So maybe we can set it in the next 30 days, if possible. And that's assuming Judge Villa can fit me somewhere, or even 60 days before the end of the year,
So a couple of things. Yes, Mr. Chavez.
I was going to say that I've also lost some mediation dates with Judge Villa, and my understanding is that he is solidly booked for the rest of the year, and it's very unfortunate because we are losing a very good mediator. We are.
But why is it canceled? That's what
Okay,
I understand.
Judge,
There's some additional information. Why did we lose this date?
Yeah, because, Your Honor, my understanding was that we got new medical demonstrating psychological injuries on behalf of the child, and so that was 2 weeks ago. And it's very difficult they need more time in order to evaluate the case, get it reported up to the carrier. 2-3 weeks is not sufficient time for them, Your Honor. And so, and that's the real reason, Your Honor. If we had this months before, then, but dumping new information so close to mediation is always not, it's not good for those reasons. And so, Your Honor, I was going to say that, right, a trial setting is what's needed, Judge. Your Honor, I know that I heard the court earlier say that you guys are setting out trial settings a year from now.
But that's on those new cases. You all have had a trial setting. We started, our first scheduling status conference was May 2023. So you had a May 2024 trial date. That got pushed back, and I had you set for trial for July 31st. And I'm just gonna, well, no, I'm sorry, August 2nd. And I'm just gonna assume in those settings, someone told me you were going to mediation, say in the next 2 weeks. And I said, okay, we're gonna let you go and do that. And now obviously we've gone past 1-2 trial settings. So no, I don't know that I'm going to extend, we have to get you a trial track, but it's not going to be September. We're talking like April April, May, where we were originally, and now we're 2 years into this case with a trial setting. I am going to order, so a new scheduling order, but we're not going to use that mediation deadline in the scheduling order. I don't even know if we necessarily need a scheduling order. You are going to have an order requiring mediation by December 13th of 2024. Okay. And if you all need anything outside of those dates, let me know and we'll get you set. Okay.
Thank you, Judge.
All right. Thank you for your time.
Thank you, Your
I
Honor.
apologize again, Mr. Chavez. I think I was still reeling from the previous hearing. Sorry.
It's okay, Your Honor. It's fine. Thank you, Judge.
Take care.
All righty.
Bye-bye.
Thank
Thank you,
you.
Judge.
Bye-bye.
Bye, Sergio.
Bye-bye. Bye, Daniela.
Bye, Erica.